You're assuming anyone's watching.
Right. Okay, so we are now live on YouTube. I'm going to call the case 122439 Cybertron International versus Chase Davis, Michael Capps, and International Technologies of Kansas. And it's my understanding, really, we're just here on the Michael Capps and International Integrated Technologies. I think that Century Technology is out of it at this point. Is that correct?
That's correct,
Yes.
Your Honor.
Okay. So the judges and I have, well, first, if you'd please enter your appearances for the parties.
Mike Bomberger on behalf of Cybertron International Incorporated, the appellee and cross appellant.
Okay.
Martin Peck on behalf of Michael Capps, the appellant.
Okay. The panel discussed this a little bit before you came on. Since we do have a cross appeal here, we are going to allow each side 20 minutes to argue instead of the normal 15, and each side will be given a chance for rebuttal. Cross appellant, you'll be given time to rebut just that portion of the argument. So does that seem fair to everybody? I want to make sure we have enough time. And you'll find that we're pretty lenient on our time standard anyway. We want to make sure that we hear and understand all the arguments made. Just for those people watching who don't know anything about this case, I'll just very briefly say that this is a situation in which an individual sold their company to another group. Michael Capps sold his company to Cybertron International. There were some basically non-compete type agreements in that contract. And this case is about whether or not Mr. Capps has violated those non-compete agreements. That's the bare bones of it, although there are some more technical issues involved. Do the parties agree that's kind of what was I accurate in my very brief statement?
Generally, yes. Yes.
Okay, generally, yes. Okay. All right. We have read the briefs. We are familiar with the facts of the case, so you don't have to spend a whole lot of time discussing those, although this is a rather fact-intensive case. With me today on the panel I'm Karen Artelberger. I'm the Chief Judge of the Kansas Court of Appeals. With me today is Judge Kim Schroeder, who has been a member of our court for probably 7 or 8 years now. Before that, he was a district court judge out in the far southwest part of our state in Hugoton, the Hugoton area. Also joining us today, we are fortunate to have Senior Judge Richard Walker. Judge Walker became a senior judge with our court upon his retirement from many years on the district court, a trial court down in the Newton area. So with that, let's see, Mr. Peck, you'll begin. And did you want time for rebuttal?
Yes, Your Honor, probably about 5 minutes, but I don't expect I'll use it.
Okay, so you will have 5 minutes of rebuttal and you may proceed.
Thank you, Your Honor, and may it please the court, as you noted, the court's read the briefs. In the factual recitation you gave, Your Honor, at the outset, the issue you raised or noted was whether or not Mr. Capps had violated the non-compete agreements or contained in the sales documents. We didn't contend seriously in terms of our defense at trial that at least some breaches had not occurred of the technical language of the agreements. Our principal defense at trial and our principal thrust of both our appeal and cross appeal is that if the court applies the rule that I like to call all the way back to Kimball versus Farron, the non-compete or the penalty provision, that's what it is a penalty provision, it's unenforceable. And
I should have been clearer on that, but you're right. You can test whether or not this provision in the contract is even governs this at all.
That's correct, Your Honor. And because in the event I'm wrong about that, then really, the question is not so much whether Mr. Capps owes Cybertron some money, but how much. But it seems to me that some things are clear about the law. I think the rule coming out of Kemble versus Farron is, in fact, the Anglo-American rule, and has been, so far as I can find, uniformly enforced by American courts. The difficulty that I have is that it has been less than clearly articulated by Kansas courts. It's been clearly articulated by Kansas courts in some cases and not in others. And so, the difficulty I have is if you read across the arc of Kansas appellate court law, what's the rule? And why is that the rule? And that's hard to figure out. And so one of the reasons why I cited sort of ad nauseum authorities and courts from other jurisdictions is just to try to make clear that although we don't have a whole lot of law on this in Kansas, this really is the rule. And I don't think that anyone would dispute that a penalty provision is unenforceable. And I think that's kind of black letter law that, you put a penalty provision in a contract. If it's a penalty, it's void as a penalty. And you
Mr. Peck, what qualifies the violations to be either liquidated damages or a penalty?
Well, of course, the question is, purpose. And I think the Kansas courts have accurately articulated that, if it looks like this was a fair estimation of the damages that might flow from a breach from before the contract was made, at the time the contract was made, that that it can be a liquidated damages clause. Kansas has not, I don't think, adopted what I believe to be the restatement position that, you can look back and say, well, this is clearly out of bounds. I think the concern that, or the observation I would make about the clauses in this case are that, it covers everything. I mean, no matter, if Capps went to the rooftop and screamed that Cybertron was a bunch of jerks and you couldn't even prove that anybody had hurt him, I think that probably violates the statute, or not the statute, sorry, the provisions. And, that ticks
But
off.
counsel, isn't the whole point of a liquidated damages clause is that we're going to agree that these are the damages because we understand they may be difficult to calculate on any individual basis. So we as a contract matter are going to agree that this is what the damages are going to be. And what's the impact of the ability of the parties to contract and the fact that Mr. Capps agreed to this provision, that this was going to be a liquidated damages provision, and he was going to adhere to that.
Well, if I can unpack that a little bit, I think working backwards, there's no question, I don't think that even Cybertron is arguing that if this is a penalty provision, it's enforceable regardless. I mean, penalty provisions are unenforceable. So I don't think there's any question that there are limits on parties' freedom to contract with respect to pre-agreed consequences for breaches. The question is whether those pre-agreed consequences for breaches are penalties or, in fact, a true liquidated damages clause. And in this
so your
case, argument
would be they could not rely on the liquidated damages provision. They would have to prove up if they're going to if they believe that he cost them business, then they're just going to have to prove up each case individually, separate and apart from the liquidation clause. Because
I wouldn't argue that, Your Honor. I mean, one of the things about this case that indicates that even Cybertron thinks this is effectively a penalty is they didn't limit themselves to even attempts to take business. I mean, if you look at the list of alleged violations, they go everywhere from you attempted to poach a customer to, you advise someone to open a bank account. And so, had the contract said, if you steal one of our customers or try to steal one of our customers, you owe us $50,000 and we can't really figure out, what the consequences are. If that had been what the contract had said, and that was how it was enforced, I don't think I'd be here. Now, I think we'd be here on a very different case because, of course, what Mr. Capps did and tried to do are different than, that's a much shorter list of violations. But that's not what the contract said, and that's not how it's being enforced. Had Cybertron started this case by saying, we understand that taken literally, this provision is hyper broad, and therefore there are penalties lurking in here. We're not going to interpret it that way. We think all the parties understood, and Cybertron, when they calculated or estimated what they thought the cost of the violation would be was the loss of a customer, then we're just going to limit ourselves to losses of customers, and maybe we'll talk about the attempted loss of customers. But again, that's not what they did. I keep coming back to, you advise a competitor to open a bank account. I don't know how you run a business without a bank account. Now, maybe I'm biased, that we continued this case so I could go to a school on agricultural lending. So I clearly am, spend some time as a banker. But the assertion that kind of breach, which does in fact literally breach the language of the agreement, I think just screams this is a penalty, and it's intended to be a penalty. Had it been narrower, I would be with you, Your Honor, in the question. Of course, parties can look ahead and say we don't know what the damages are going to be, and frankly, we don't want to fight about it. But the law of every English-speaking jurisdiction, I believe, requires that there be some analysis of, hey, are the breaches we're talking about likely to cause the kinds of damages we're talking about? And
was there any dispute that, and again, I know this doesn't get to your legal argument, but is there any dispute that Davis took 6 customers? There 6 customers left Cybertron to go with Davis after Capps had consulted with Davis. Is that, regardless of what he consulted with them about? And I understand you may say that, he can consult with them on some things and not others, but is there any dispute that after he consulted with them, they took 6 Cybertron customers?
Your Honor, it's been a while since we tried this. I don't recall that being in the record. If it's in the record, we did not dispute it.
Okay.
But I don't remember that being in the record, but
okay.
It's been a while, and I did not reread the transcript in preparation of this hearing.
Okay, I'm sure Mr. Baumberger will recall.
Counsel, if I'm understanding your argument, you're saying if it's a penalty for one issue, it's a penalty for all.
I think that's the law. I think it's not a matter of you can pick and choose. I think if the law is as I read it, if it's a penalty provision, it's void. Now, I think what Judge Mitchell Hernandez tried to do, and I don't know if the law permits this, but I think she certainly, tried to impose some reasonableness on these provisions. She basically said, "Look, I'm not going to tick all these boxes. I find that most of these things happen, but you don't get $50,000 for the bank account." But she did lump those together as sort of advice and call them one event. I'm not sure the law gives the court the discretion to do that, but I certainly understand the impulse to attempt to impose some rationality on the provision.
Well, did she have authority under the contract to lump them together and find one penalty? Or one liquidated damage amount?
I don't think that's how the literal language of the contract reads. I think it's just
not how the plaintiffs pled it.
It is certainly not how the plaintiffs pled it, and I don't think that's the literal language of the contract is every single thing you do, everything, and whether it's even plausible that it will hurt us, is a $50,000 judgment.
But I
And
think,
so-
didn't she say everything that, that basically to say, he helped Davis by doing this, and this. The violation is he helped Davis. And so to nitpick every single item is not appropriate. The best analogy I can think of is in the criminal field, where we have this theory that generally you're not going to get, if you steal a bunch of stuff from a department store, you're not going to get charged with a separate count of theft for every item you steal. You're going to be charged with theft for all items combined. Generally, that's a decision for the jury. But there are, I mean, that is kind of the analogy that came to my mind when I read what she did.
And Your Honor, I don't know that Judge Mitchell Hernandez actually said this, but were you to interpret her findings as, I find as a matter of fact that the following 6 things are all actually components of one thing. And I don't think she articulated
But she didn't
it quite
articulate
that way. But if you were to interpret it that way, that would, I suppose, be a way to impose, again, some rationality on these provisions. But again, I think the way that Cybertron reads this provision, it's, if you steal a book of checks, you've committed 25 thefts because there's 25 checks in the book. And if we really feel like it, there are probably some deposit slips stapled on the back too. And so, in terms of how, narrowly sliced the allegations were, you did the, Capps did this for this entity, and then he did it for the same person, asked for the person, formed an entity. And so that's another count. And he said something about a bank account, very thinly sliced. And that was, I think, how Cybertron tried it. And that's how we defended it. Now, the fact that they tried it that way and defended it that way imposed, I suppose, some limits on the court, but only some. Right. I think that the court could say something in a case like this, like, look, we're going to determine that, the provision is valid for some things and not others. If the court were to do that, I mean, as a matter of jurisprudence, I would suggest strongly that the court articulate what the rule was. In fact, whatever you do in this case, from the point of view of somebody who might at some point write another brief on this subject, the clearer you can be at what the rule is that you're applying, the better. I mean, one of the frustrations about writing this brief was, and obviously this panel didn't do it. I mean, this is Kansas law of the course of the last, 110 years or something like that. But, what's the rule is, in my mind, was hard to divine in terms of clearly what the rule was. And I don't think that any of the panels or of the courts that did what they've done were intending by the language they used to alter the standard Anglo-American rule, but they didn't say one way or the other. And so whatever the court does, a clear articulation of the rule, I think, would be helpful to both future courts and future litigants. However, I think,
just to be clear, you're talking by the rule, you're talking about the difference between something that's a penalty and something that's valid liquidated damages. Is that what you're talking about?
Yes, sir. And also, the courts have been a little unclear in my mind about if a damage provision applies to big things and little things, does that render it invalid, and why? There's at least one court, and I apologize, that indicated that the reason that renders it invalid, at least as on that panel's thinking, was that it suggests the parties didn't really think about it. And because they didn't think about it, it's not valid. Well, if that's the rule in Kansas, that rule is idiosyncratic to Kansas. And I would be hesitant to thoughtfully articulate an idiosyncratic rule. Now, some rules are idiosyncratic.
So the clarity needed is a penalty provision and it's all or an all or nothing thing? Or are there some nuances that we look at
That would be one area where clarity would
that
be
needs
helpful.
some clarity? Right?
Well, it wouldn't, the contract was drafted by Cybertron, if I recall correctly.
Yes,
And so if they could have structured their liquidated damages amount based on the type of alleged violation.
absolutely.
And this one's not tailored in any fashion. It's either $50,000 or you go home.
That's correct. Regardless of the magnitude of the violation. And again, and I guess what I would close with is this. I mean, I think that the Anglo-American rule is relatively clear that where a liquidated, what purports to be a liquidated damage provision does, Judge Schroeder, what you just said, all in everything or nothing. That's a penalty. I mean, and the Kimball case is, I mean, I had to hunt for it. It was kind of hard to find, but I also attached it because I thought it was well written. And then cited 30 some odd other cases that applied it across the jurisdictions. And I think that, Judge Posner's analysis is accurate. I mean, it's a real problem. But I think the clarity I obviously would ask for is the clarity to say, look, this is a penalty. It's a penalty ab initio and it's void.
Okay, you're into your rebuttal time now, but we've asked a lot of questions. And I'll still give you your rebuttal time. Do the panel have any other questions at this point?
I don't.
I don't.
Okay, thank you. Mr. Baumberger.
Okay, there's a lot to unpack there.
Right.
I think there's really two issues we're dealing with. The first issue is whether or not Mr. Capps has acquiesced in the underlying judgment, thereby waiving his right to appeal. Court's well aware of what the acquiescence doctrine is, the general rule. And in this case, Cybertron obtained its judgment at the conclusion of trial. And after that, Cybertron engaged in post-judgment collection actions, but yet Mr. Capps took no action to file a motion to stay execution, to file a supersedis bond, or to take any action to challenge Cybertron's garnishment of his wages with the state of Kansas or his bank account with Blue Vine Bank. As a result, Cybertron's obtained a total of $3,542.39 from its collection efforts to date. And if you look at both the VAP case, which is a 1983 Court of Appeals case, as well as the Supreme Court case, which was the Hewitt case, which also cites to VAP, they provide that under those circumstances, Mr. Capps has acquiesced, assumed the burden of the judgment, and waived his right to appeal. So that's the first issue I think the court has to address. The second issue is if you get there is whether or not Mr. Capps has met his burden of showing that the liquidated damages clause in the restrictive covenants agreement is somehow a penalty and therefore invalid. In that instance, to try to unpack some of the arguments here, Mr. Capps is kind of like the guy that got caught with his hand in the cookie jar, and he's trying to say that he didn't do it, and the fact that I've got crumbs on my shirt, you shouldn't penalize me for this crumb and that crumb. It's all part of the same crumb. It's a situation though where Mr. Capps is not looking at the big picture. In this case, I think the Supreme Court case of Carruthers from 2009 tried to unpack a lot of these issues. And the problem that you had prior to the Carruthers case was that courts were doing both a retrospective analysis of damages, going back in time and going, okay, does your liquidated damages clause match up with what the actual damages were? And they were also doing a prospective analysis of damages as though the parties were sitting there at the time of contract looking forward. And the Supreme Court basically held that doing the retrospective analysis robbed the parties of the basis of their bargain. And so they've overruled that part of prior precedent, which Mr. Capps is relying on. And to the extent that he's relying on the Kimball case, the subsequent cases that relied on this argument that if the damages are the same regardless of minor or major violations, that is the wrong test. That's specifically stated by Carruthers. That's just the wrong test. Again, you're getting into a retrospective analysis of damages that robs the parties of the basis of their bargain. In this case, I think one of the things that's a little bit telling is Mr. Capps was required to consider a lot of different factors under the Carruthers test. Now, Carruthers really relies on two main factors, but there's a lot of other factors that should be considered. For example, what was the status of the parties? What was the subject matter of the contract? And there's other factors, but the main two factors that largely get litigated are the last two factors, and that is, the first factor is whether or not the damage amount is reasonable when viewed prospectively based upon the subject matter of the contract and the presumptive loss from a breach. And then the second is the second factor is whether or not the actual damages would be easy or difficult, I guess, difficult to determine in the event of a breach. And in this case, when you look at the different attacks that Mr. Capps had on that first element, the first main element, he never addressed the background facts of the case. And I think it's really important for the court to understand that we're dealing with an asset purchase agreement. Both Cybertron and Integrated Technologies of Kansas were IT businesses which provided those services to customers in Wichita. Cybertron was purchasing the customer accounts contract, customer contracts, and the revenue stream from ITK's customers. And they were going to pay Mr. Capps and his business a significant amount of money for those. So in conjunction with that asset purchase agreement, they executed this restrictive covenants agreement. And it really was a twofold purpose. Number one, to induce Cybertron to enter into the agreement, and second, to prohibit Mr. Capps and his company from competing for a 5-year window of time. And Cybertron was giving a lot of money for that. They knew that they were supposed to be getting $50,000 in revenue per month from those customers. So I think the agreement itself, when you look at the subject matter, that makes the liquidated damages amount of $50,000 per violation reasonable, because Cybertron's owner, one of its owners, sat down and tried to figure out what's going to happen if we lose one of these customers. We can foresee that if a breach occurs to any one of these three restrictive covenants, then we could lose a customer. And so they tried to figure out what's the revenue likely to be from one of our customers, as well as what's the revenue likely to be from one of the ITK customers. And that's how they came up with the $50,000 amount. So
Counsel?
I think that's really
Counsel?
important. Yes.
So there was testimony that your client calculated for the loss of a customer at $50,000, and he rounded it down to 50,000. All right. So, but I also think there was no testimony as to what the value would be if Mr. Capps went and helped somebody else open a bank account, or if Mr. Capps told the guy to call Cox Communications to obtain services for himself. So there was no calculation for that figure, and for it to be a determinable amount or undeterminable amount that was incurred by Cybertron if a violation happened. Is that right?
Yes. If I can respond to that, the general idea going into this was the idea that we could lose a customer. And I can go through each one of the covenants and show how it's foreseeable that Mr. Capps's conduct could result in the loss of a customer. Mr. Capps wants to trivialize everything that he did. But if you look at some of these violations, for example, one of the violations is he's giving advice to a competitor on pricing. And he's admitting in testimony that if a competitor has a better pricing model, then they could basically steal 20 to 30% of Cybertron's customers. So obviously not a trivial, just a little piece of advice. That's something that can have a very detrimental impact on Cybertron. It goes back to the purpose of the agreement in the first place. There's also other violations. Now, keep in mind, these are separate violations. They're not violations that happened all at one time. And there's other violations, like he's giving advice to the competitor on here's some service providers or vendors you may want to use, or hey, here's a bank account and some banking accounts that you may want to set up. Mr. Capps' whole goal in doing that was to make that competitor more effective and to grow and survive. And so again, not trivial violations. They may look trivial on the surface, but their whole purpose is to help that competitor survive and grow, which goes directly against the whole point of the non-compete, which spells out in various different clauses, thou shall not go to work for a competitor, shall not start a competing business, thou shall not have an ownership interest.
Mr. Baumberger, I understand your argument, but doesn't this whole idea of then nitpicking each particular thing that Capps advised Davis on, rather than just say Davis tried to, or Capps tried to advised a competitor in a way that enhanced that competitor's ability to take clients from take clients from your client. So it seems that in a sense, you want it both ways. You want to say each particular item that he did was a violation, but on the other hand, say, look, we look to this whole agreement was an asset purchase agreement. The whole key is we don't want him to do anything that would result in taking customers. I mean, you kind of see where I'm going here? They seem a little inconsistent in.
I guess I'm not really seeing the inconsistency in the grand scheme of things. I think Capps would like to have us just lump all the advice together and say, you have one violation, I gave advice. And when he's giving advice over months and months and months of time on different topics, that's continuing to help that competitor grow to take business away from our client. If we lump it all into one, we're kind of disadvantaged because his advice on any one of those topics could result in the loss of multiple customers.
Well, Mr. Baumberger,
pricing.
Right.
Ms. Baumberger, didn't affect I guess I'd like you to comment on the district judge's decision to kind of just take a whole bunch of them and lump them together and say, well, these may be minor, but when you stack them all up, it's $50,000. I mean, did the judge have authority to do that?
No, because the contract doesn't provide for groupings of or categories of damages. It provides for liquidated damages for each violation. And it really was kind of unexplainable to me how she went through the first 8 violations and gave different reasons for why we didn't meet our burden, so to speak. And then after awarding us damages for the last 3 violations, she backtracked to the first 8, lumped them all together, and gave us $50,000.
So what should we do about that?
I think we have to go back and break down and go through each violation and determine whether or not, and this kind of gets into the cross appeal, obviously, that we need to go back through and analyze each violation separately and determine whether or not the court had an erroneous conclusion of law based upon the interpretation of the restrictive covenants agreement, or whether it was a negative finding of fact where the court was arbitrarily disregarding the uncontroverted evidence.
Okay, I as I understand this purchase arrangement, Capps received $550,000 worth of stock from Cybertron.
Correct.
So if that was the case, why didn't Cybertron execute on that stock to satisfy its judgment?
Have a judgment, yeah.
Yeah, that is.
Oh, you're talking about instead of garnishing. I'm sorry, Judge.
Right.
Is that what you mean?
Right. Well, they'd execute on the stock
Realistically, there was an issue, and this gets into collateral situation. I don't know if it's really relevant here, but Mr. Capps claimed bankruptcy. That was an asset of the bankruptcy, and Cybertron essentially had to buy that asset back through the bankruptcy. So I don't know that we could have executed on that somehow and got money back out of him for the value. We could have got the stock back, but essentially we were under a put call agreement with respect to that stock. So we had to buy that stock back through the bankruptcy.
All right.
But I guess at the end of the day, I don't know how much time I have left, but at the end of
You've
the
got
day,
about a minute and a half on your
okay,
first set of argument.
it's really just an effort to minimize and trivialize the damages. And I think if you get into a situation where you start saying, well, this damage isn't as severe as that damage, then you get into that retrospective analysis again, and you're comparing that to what you thought. You're comparing that to the liquidated damages. And I think anybody who's violated one of these clauses is going to come back and try to do the same thing. They're going to say, well, you didn't try to calculate every type of possible violation that I could have committed. And therefore, because you missed this one violation that I could have committed, then the whole thing's invalid. Or under this one circumstance or two circumstances, if you compare the actual damages to what the liquidated damages are, the whole thing is void now. And again, it goes back to, we get away from that. The court says we're not doing that anymore. It's not a retrospective analysis. This is all forward looking. If you're sitting there at the time this agreement is drafted, what was foreseeable? And it's foreseeable that if there is a violation of the non-solicitation clause, for example, it's very foreseeable that if Cap solicits one of Cybertron's clients, Cybertron's going to lose that client because he has all the knowledge and know-how to undercut Cybertron's contracts. Likewise, if Mr. Capps goes out and violates the non-disclosure clause in the restrictive covenants agreement by sharing Cybertron's customer contract list with a competitor, that can very well lead to the loss of a multitude of customers. And if you get into the non-compete, you get into the idea that all the advice and consultation that Mr. Capps could provide to a competitor is going to be knowledge that's going to help that competitor grow and survive, just like he testified, and that was his purpose. And when that customer grows and survives, it's going to undercut and take away customer share from Cybertron. He even admitted that if a competitor was more effective, it could steal Cybertron's market share and cost them revenue. And again, if the competitor had a better pricing model, it could cost Cybertron 20 to 30% of its market share. So this wasn't trivial. It was intentional to try to help a competitor, and that you're not helping the competitor to help Cybertron.
And he was getting paid by that competitor too for that help, correct?
In the end, he took employment with the competitor after giving the competitor advice and consultation for maybe 8 months or so. He did take employment with the competitor and was doing business development and I think maybe it was marketing for that customer as well. It's in the briefs.
Okay. Any other questions at this point in Mr. Baumberger?
No.
All right, Mr. Peck, so you can present rebuttal on the issues in the cross appeal, and particularly what I would like to hear you talk about first is this issue of whether you've acquiesced in the judgment. You're on mute.
Your Honor, we didn't obtain a supersedious bond. We couldn't afford
Right.
a supersedious bond. And we did not contest any collection actions that we thought were lawful. I don't know how I could have contested collections actions that I thought were lawful. Collections are lawful in the absence of a supersedious bond. And I don't read the cases to say, you know what, if you don't bring frivolous arguments to try to stop us from collecting, and you don't buy a supersedious bond, you don't get an appeal either. That would be a very strange. I mean, the doctrine of acquiescence is already strange, and that would be a very strange application of the doctrine of acquiescence. To respond to a couple of points from the argument, that there was a large amount of money articulated in the contract does in fact mean that a liquidated damages clause that's lawful would be reasonable. but there's no amount of money you can pay to entitle yourself to write a penalty provision. You can't pay extra to violate the law of contract. None of this may be in the record because it was, we kind of got into it tangentially, and Judge Mitchell Hernandez wasn't happy about it. But there was the contention made that, gee, we paid a lot of money for this and we should be able to do what we want, because Mr. Capps, signed this in connection with getting a lot of money. The Judge Schroeder asked the question, why didn't you execute on the stock? And this may be in the record, but I'm not sure because we were having testimony. But I believe it was purchased for $15,000 from the bankruptcy estate. Now, I don't think that's material. I mean, if the purchase price was $1 million, you can't write penalty clauses. And if the purchase price was $10, you can't write penalty clauses.
So that's more of a retrospect look back. You're asking us to, or you're kind of insinuating that this was $550,000 in stock in the contract, but in reality, it was only worth $15,000 in the end.
Your Honor, I don't think that's relevant.
Yeah, right.
I don't think those amounts are relevant, but the court asked, and I just wanted to.
Okay. All right. Okay.
But no, I don't think it's relevant. I think if it's $1, $1 million, $100 million, you don't write void clauses, and you can write reasonable, prospectively reasonable liquidated damages clauses. Again, whether the price is $1, $100, whatever. And consideration, I think, only requires a peppercorn. Had this contract,
but the heart and soul of this liquidation provision, or this damages provision, the heart and soul of this were the assets of the company. And how do you respond to the fact that every one of these provisions as to how you can violate directly related to the potential loss of that asset, loss of those customers?
I don't read the provisions that way, Your Honor. I think it's straight up a penalty. You make any
right. I know you believe that.
Any way, whether it has anything to do with our customer base or not. And they wrote the contract. They could have said, if you take a customer or try to take a customer, that's a violation.
Right.
That's a $50,000.
Well, and the amount, it's my understanding from reading and I can't remember if it was I read it in the record or in the briefs, the $50,000 was really an amount that Capps presented as the value of.
No, Your Honor.
Your client presented that. Oh,
no, Your Honor. No, Your Honor. We doubt as a factual matter that it really happened the way it was testified to. We had no way to contradict it.
Mm-hmm.
We have no way to figure that out. And we were, no way to present rebuttal testimony. But no, Mr. Capps was not the source of that number. Mr. Capps, I believe, denied that any such, calculation was made, but we don't have any way to know what was going on inside Cybertron's head. And if they made a calculation, and that calculation was reasonable with respect to foreseeable violations of the covenant, then the amount's valid. But
right.
But the trouble is, there are we're not just retrospectively. There are zillions of foreseeable ways to violate these restrictions that have nothing to do with those damages.
Okay. All right. Any other questions in the panel for Mr. Peck?
No.
Okay. You've got 5 minutes, Mr. Baumberger.
For extra rebuttal. I don't know that I need to say much more. The $50,000 number, to the extent that you're asking about whether he said that the monthly value of the ITK accounts revenue stream was $50,000 a month. If that's what he's arguing about, then that's the only testimony that was put forward is that was what we were told. And I don't think there was any rebuttal on where that $50,000 a month revenue came from.
Was it $50,000 a month, or I thought it was just the total value of a customer was $50,000.
Okay.
They were paying. I thought it said like $2,000 a month. And over the life of the term of that customer, it was estimated that that would result in about 50,000 per customer.
Okay, so,
I mean,
okay.
am I right on that?
now-
Or
Well, now I understand where you're coming from. I think I misunderstood your question. There's two different $50,000 amounts, actually three. There's the representation from CAPS during negotiations that the the ITK accounts were going to generate $50,000.
right, that's what I'm talking about.
So that's where that 50,000 a month revenue came from. But then you have the other $50,000 amounts coming from Mr. Marcos trying to do an analysis of what the average Cybertron customer would generate over a 3-year period. And then he goes and looks at the ITK customers and determines there's 35 customers. We're going to get $50,000 of revenue from a month from those customers. When he divided that out,
Those consolidated, okay.
something like $1,400 to $1,500 a month. And over 3 years, that's where he came up with 50,000 for those customers over a 3-year period
Okay,
per
thank you.
customer. But other than that, I think I've covered everything else that
Okay.
I need to.
Any other questions from the panel?
No.
Okay, thank you all very much. It's a very interesting case.
Wait a second.
Uh-huh.
I didn't think that the cross appeal was argued.
Right.
Well, I kind of got into it. I kind of led Mr. Baumberger into
What do
it.
you mean the cross? I'm confused now myself. I thought you were making all of your arguments, and that's why I gave you then rebuttal time too.
Yeah, I think I was confused then because I was under the impression we were still under the initial appeal.
No.
If with regards to a cross appeal, I wouldn't have a lengthy argument.
Well, you've got about 3 more minutes. So.
Okay, well, there's really two issues on the cross appeal. Number one is Mr. Capps hasn't dove into the merits of any of the arguments on the cross appeal, so I'll stand on my brief on that. As to another issue, I would point out on the issue of prejudgment interest. I didn't add into my brief the idea that we could calculate dates for the different violations so that prejudgment interest could be calculated. Out of the 11 violations, 6 of those violations, we have an email that sets the date of the violation. As to the other 5, we have a date range that we can work with, and we could use the last date of those to get the starting date for prejudgment interest. Outside of that, I would briefly touch on the issue of acquiescence since Mr. Capps brought that up. We know that the acquiescence rule has some exceptions, and our position is that the severability exception applies here. And I think it's pretty clear that the court made separate rulings for all 11 violations, as well as separate rulings on prejudgment and post-judgment interest. What Cybertron has tried to collect on is not inconsistent with their cross appeal because they're not trying to collect on monies they're disputing in the cross appeal. And the money that Cybertron has received hasn't even come close to covering one of the violations that Cybertron does agree with. I've cited to 3 different cases that deal with the severability exception. I think they're all applicable here. The first 2, the Woolard case and the Brown case, are on the opposite side of the V, but the same rules should apply. Those are situations where the defendant or judgment debtor pays part of the judgment and appeals the rest, but that same analysis should be applied here where the judgment creditor receives payment for part of the judgment and appeals the rest. But I think the most on point case factually is probably the last case, which was the Halpin case, because it deals with a judgment creditor trying to go forward with appeal, and the judgment debtor is saying, well, you got some money on one of your claims and that should forego your appeal on the others. And the court found that no, the money that you received on one of those claims has nothing to do with the claim that's being appealed. I think the Almec case and the Ullman case are not really applicable here because they don't deal with the severability exception that I'm raising. Obviously, there's issues with the Almec decision that's been addressed, I think, in the Ullman decision. And again, if you look at some of the claims that Cybertron is actually trying to seek post-judgment collection efforts on. They haven't received any money on those. At best, we've received a little bit of money on one. So if Ullman was applicable, it would basically say that those claims that Cybertron agrees with and has tried to collect money on, they haven't acquiesced in because they still haven't received any money on. So I think that's my short argument.
Any comments from the panel?
No.
Okay, I think we're done now. I think maybe I totally confused everybody with how I said we were going to proceed at the beginning. Okay, well, it was really very helpful argument from both of you, and very, very well done briefs. This has been an incredibly well argued case, and we appreciate that greatly. We will take the matter under advisement and get you a decision as